I believe we are on the record, Your Honor.
Thank you very much. Good morning and welcome to the Supreme Court. We have one matter on for today, which is State versus TIJUAN GIBSON. Each side will have 30 minutes to argue. The appellant may reserve any portion of that time for rebuttal. I believe you're both aware of the process that we're using in the virtual platform, so we won't go over that. Appellant, are you ready to proceed? You unmuted and then you muted again, counsel. There you go.
May it please the court, Attorney Alice Osadak from the Office of the Chief Public Defender, representing the appellant. May I please reserve 5 minutes rebuttal time?
Thank you. You have your 5 minutes. Justice McDonald will be our timekeeper. Just to refresh everyone's memory, what will happen is the justices will either raise their physical hand or their virtual hand. Once you see that, when you get to your next logical stopping point, if you'll pause, I'll call on the justice to ask the question. With that, counsel, you may begin.
Turning to the defendant's first claim in this case, and that is that the trial court erred in admitting the prior consistent statement of a state's key witness. There was not a sufficient legal basis and it was harmful. This was hearsay. It unfairly enhanced this witness's credibility, and even when offered for rehabilitative purposes, there's very limited circumstances under Code of Evidence 6-11B to enter this type of prior consistent statement. I would refer the court to page 9 of the defendant's brief, which sets forth the relevant testimony. Her complete testimony is in the appendix at 113, and her statement is at 211. And it was after the cross-examination and right during direct that the state asked that the entire prior consistent statement of this witness be entered into evidence. And trial counsel fervently objected to this throughout the proceedings. There were several objections, and eventually almost the entire written statement was entered into evidence. A fair view of this witness's testimony would have not left the jury with the impression that there was somehow either she was somehow either impeached with a prior inconsistent statement, a suggestion of bias, interest, or improper motive, or a suggestion of recent contrivance. When you're viewing the entire testimony, it was clear that when she was testifying that the defendant was someone she knew from the neighborhood, she recognized him as the shorter male, and she recognized him as someone that she heard yelling towards the victim. There's nothing in her prior consistent statement that would have, I think I see a question.
Yes, counsel. First, we have Justice McDonald and then Justice Kahn.
I didn't have my hand raised, Chief.
My apologies. I thought I saw that. Justice Kahn.
Thank you, Chief. I think it may have been Justice Ecker, but for an interest
go ahead.
of time,
Go ahead first. That's fine.
Thank you. Counsel, I have two questions. One is, even assuming it had been error to admit the entire statement, how was it harmful? Basically, the statement, I guess I'm struggling with the harm aspect of it. And then my colleagues may have questions about this area, but I really want to direct your attention to the one issue, and that is the issue of the cross-examination of, I believe, Mr. Roach's pending charges. And if you can address that issue at some point in your argument, I was going to ask you about that. But if you could answer the question of, you know, the court sort of viewed the cross-examination as basically alleging that this witness fabricating is fabricating her identification of your client and allowed the statement to come in as sort of indicative of the fact that even back then, although she didn't say she recognized his voice, she said she couldn't see them very well, but the shorter guy looked to her like Fly, like the guy she knew as Fly, who then ran to the house that she would see him at. So I guess I'm wondering how that amounts to harm.
Well, first off, I don't think it fit any of the exceptions under the code. And most specifically, the statement did not rebut, even if there was some type of suggestion of contrivance. There was nothing in her prior consistent statement that rehabilitated her in the sense of how she further recognized the defendant's voice. Her statement is consistent as to what she testified, and she testified that it was not in her prior statement to the police, that she had not told them how she recognized the defendant's voice. So the prior consistent statement did not rehabilitate her, first off. But in terms of harm, yes, yes, go ahead.
When I read the questions, at least initially, counsel was trying to suggest that two things she made up, not just that she recognized his voice, but that she heard him say, or she heard them say to Savian, the victim, leave, telling him to leave, which was in her statement. And when you get to the harm issue question, you raised this as a constitutional claim. I'm struggling to see how this is a confrontational issue, because she was on the stand and she was cross-examined. So to me, it seems like an evidentiary issue, which is a different harm analysis. Would you agree with that? You're not claiming this raises the level of a constitutional claim, do you?
I do, in the sense that I think the trial court erred because she had too broad of an interpretation to allow this evidence in. And even an evidentiary ruling, when it is interpreted too broadly and it's not an unfair admission of evidence, that it could have a deterrent or a chilling effect on a defendant's constitutional rights to confrontation. That's the aspect of the constitutional claim, because I believe that it was so, there were no legal grounds to support the admission of this evidence. But in terms of evidentiary harm or harm in general, there's no doubt that this was a state's key witness. She was the main witness. The accomplice Snow also testified, but he obviously testified that he had a cooperation agreement. He testified that he was untruthful in many aspects of his statement. And I think that even by the jury's verdict, in that they acquitted the defendant of murder, that they didn't believe all of Snow's testimony. Atkinson, on the other hand, she had no cooperation agreement. She had no pending cases. She was a neutral or independent witness. And most importantly, she was the only factual witness of the observations of what occurred right prior to the shooting. She was observing this out her window, and she identifies the defendant as someone she's familiar with from the neighborhood, someone that she recognized as a shorter male. And I think I see another question. So
I know Justice Ecker has a question, and I just wanted to follow up. I'm still struggling. Are you saying that it's a constitutional violation and therefore the state carries the burden to prove that it was harmless beyond a reasonable doubt, or that you carried the burden to prove that it prejudiced your client? You're kind of walking both sides of the issue there. And that's my last question. And then Justice Ecker, I'll refer back to the chief. If you can answer that, a clear answer. Are you claiming a constitutional violation, or are you claiming an evidentiary?
I am claiming both, that it's an evidentiary ruling that was an abuse of discretion. And I'm also claiming that it was such an evidentiary abuse of discretion that it rose to a constitutional level, in a sense that it could have a deterrent or chilling effect on the defendant's constitutional rights to confrontation. And under either standard, I think the harm is established in this case. There's no doubt that she was a crucial witness for the state, because she's not a cumulative witness. She's the only witness that was observing and placing the defendant near the scene of the shooting, and most importantly, that she claims she saw him go over that wall and then she heard gunshots. She clearly corroborates Snow's testimony, and she was very crucial witness. And it was also contrary to the defendant's theory, which was his mother lived in the area. He was out and about that night. He may have been on the street, but he wasn't involved in this actual crime. The state, in its closing argument, heavily relied on her testimony and pointed the jury to the fact that she's an independent witness. She had no motive to lie, that it was crucial, her testimony of seeing him go over the wall, that she corroborated Snow in many aspects, that she was the one that proved that the defendant was the aggressor, the robber. And the jury didn't easily reach a verdict in this case. They relied on Atkinson's testimony, and I do see that there's
Thank you, counsel. I know my colleagues have questions. Thank you for answering my questions. I yield back to the chief.
Thank you, Justice Khan. Thank you, counsel. Justice Ecker and then Justice Doria.
I had a question about harm as well, and you've gone through that, so I'm all set on that issue. Like Justice Khan, I did want to hear about the Roach issue and some of the things the state said in response to that, but I see Justice Doria also has a question, so I'm done. Thank you.
Justice Doria. You're muted, Justice Doria.
Sorry. Why don't you just answer this brief question and move on to Roach, if that's your judgment. You say in your brief that the evidence that the state presented showed that Snow was the shooter. Can you summarize how that was so?
Well, I think that the evidence, Snow testified, the co-defendant, that the defendant actually was the shooter, but there was no evidence other than Snow's testimony that that was the case. And a weapon was not found in this case. There was a lot of DNA evidence that nothing came back to the defendant.
Okay. So you're not saying there was any affirmative evidence of the state's, and you didn't put on any evidence that suggested, I mean, other than that he was protecting himself by testifying that Snow was the shooter. We don't know, other than his own testimony.
We don't know, no. I
Okay.
mean, and I think by the verdict that the jury reached, they didn't totally believe, I interpret that as that they did not totally believe Snow's testimony that the defendant was the shooter.
I got you. Okay, thank you.
And if I would just like to briefly address, I think I see another question.
Yes, counsel, I have a question. You talked earlier about the chilling effect on the defendant's constitutional rights. What was chilled? What did he not do that he otherwise would have done, or felt that he couldn't do that he otherwise would have done?
Well, I think in the sense where if the court permits an evidentiary ruling to be interpreted so broadly that the exceptions will swallow the rule, trial counsel may be hesitant to cross-examine someone about something. The state originally brought this up in direct in concerning how she recognized the voice. Counsel may be more hesitant in the future to explore that in fear of opening the door to a prior consistent statement. And my only point on that is that if it is an abuse of discretion for an evidentiary hearing, an evidentiary claim on something like this, but if the court doesn't follow the rule, it could have a deterrent or chilling effect in the future on his right to confrontation. They'll be more hesitant to cross-examine on something like this. In terms of the harm, I think I just wanted to point out some other things on this. And one was the DNA evidence. Nothing came back on the defendant. And the other thing I would ask that this court look to is that trial counsel zealously throughout the proceedings attempted to have the judge reverse her ruling before the statement was entered. And I think oftentimes the court will look to the actions of trial counsel. And trial counsel was there at the time. He was aware how important this witness was to this case. And I think you should take that into account. And also the court's limiting instruction, because counsel did ask for limiting instruction if you are going to give this evidence. And the court's instruction immediately prior and after did not ever tell them that they could not use this for the truth of the matter, only that it was for rehabilitative purposes. And I think I see another question.
Thank you, counsel. Justice Keller.
Thank you, Chief Justice. Good morning, Attorney Ozadok.
Morning.
I had a problem, and you just raised it with the judge's curative instruction. I didn't think it was very curative. It never told them that they could not use that statement for proof of the truth of the facts contained therein. Is that, how do we get around that not being sufficient? Even if everything else was fine. Jury wasn't told that really clearly told how to use that statement for the limited purpose it was supposed to have been admitted for.
Your Honor, I totally agree that the instructions were not total. They did not ever explain to the jury, and the jury would not know just by her instructions that they could not use it for the truth of the matter asserted. She told them they can use it for rehabilitative purposes. And I think
that underscore the harm, whose ever burden that it is to prove or disprove it?
I think
does that underscore harm, you think, the failure to give a proper curative instruction?
It definitely goes to the harm, yes, Your Honor. It shows that this jury most likely did misuse this evidence. And again, the statement that was entered was pretty much her whole statement. I mean, it was a statement that said she voluntarily came to the police. It was her statement concerning all of her allegations of what she observed out the window. It wasn't just a statement that went to her identification of the defendant. It very much unfairly bolstered her entire testimony, and the jury did not easily reach a verdict in this case. They were deadlocked at one point, and they reached a verdict after they heard Atkinson's testimony again. So she was a crucial witness, and this, again, unfairly bolstered her credibility, and also was not a case where counsel was able to really vigorously cross-examine this witness or discredit her in any other way. And I believe Judge Keller has another question, or?
I do have one more, and that was, you said that he was chilled because he didn't want to bring up the statement, but he began his cross by bringing up what wasn't in her statement. So what was chilled if that's where he went right to attacking her about what was lacking in her statement.
I guess my point again with that, with the effect, is that if the evidentiary ruling can be upheld as a proper ruling when it was so outside of the circumstances of the code, that in the future this could have a deterrent or chilling or impinging effect on a cross-examination, on a witness's cross-examination.
But as to this case, where's the chilling effect? You're talking about future cases.
Yes, I'm talking about future cases. Future. Okay. All right. Yes, if it can be interpreted this broadly. And one other point I'd like to make is that this case is very much similar to State versus Moody, an appellate court case that I mentioned in my brief, where it was almost the exact same circumstances, where a defense witness mentioned something on direct about why they were he and the defendant were at an intersection where the crime occurred that he didn't place in his prior statement, in his lengthy prior statement. And the state brought that out, and defense counsel sought to have his prior statement come in, but the witness admitted that it wasn't just like here. The witness admitted that she hadn't placed what was at issue in her prior statement. The court found that it wasn't a suggestion of recent contrivance, and it wasn't permissible to let that entire statement in because it didn't rebut anything. And it's very similar to the situation in this case. It was error for the court to admit this evidence, and it was extremely harmful. In
Justice
some,
Khan,
yes.
one second, Counsel. Justice Khan, you had your hand up, but I don't see it now. Did you have a question? You're muted, Justice Khan.
Yes, I do, Chief. Thank you. For some reason, it went down on its own. Thank you. I don't know why. Counsel, I really would like you, if you would address the Roach issue. I do have a question on this chilling issue. Basically, what you're saying, then, anytime counsel, defense counsel, or anyone impeaches a witness with a prior inconsistent statement, then the prior inconsistent statement is then used for rehabilitation, we would have a chilling effect on cross-examination. That can't possibly be the standard, would it? Because then basically defense counsel would never attempt to impeach anyone. This is routinely happens in cases. Whether or not the entire statement should have come in, whether it should have come in at all in this case is an issue. But in terms of chilling, I mean, you'd be basically saying then no, that there should never be an ability to rehabilitate somebody with a prior consistent statement. Otherwise, that would have a chilling effect. And I'm not sure that would be the test. If you can comment on that, and then please, if you so deem appropriate, to go to your Roach argument.
Again, on the chilling aspect of this, it's not. Again, if you look back at, and I didn't go over all of the judge's rulings in this. Initially, she just said it's admissible to shore up the impeachment. That it's admissible to shore up the impeachment. Then later she said it's analogous because to a deposition because counsel suggested something was left out, and we're going to put it in to show that it wasn't left out. And what I'm saying is that if the admission of this was in such error and outside the rules for admission, and that trial court is able to do that, then that would in effect have a chilling effect on a constitutional right to confrontation in the future. And I know you want me to address the Roach issue, and specifically in that trial, again, the trial court erred when it clearly prohibited trial counsel from cross-examination on any of the pending charges with this witness. And I know at the end she did make a ruling concerning that he may cross-examine the witness in terms of bias or interest, and but it wasn't very clear, and it seemed that the court's entire ruling was that unless he could somehow connect it to this case, to the pending case, then he was not able to ask, or unless the witness had a cooperation agreement, that he wasn't allowed to ask anything pending charges of the witness who had pending charges in the same court. And that was my point on that. I think there's a question.
I'm not sure of the order. Justice McDonald and Justice Doria, I'll do it by seniority.
Thanks, Chief. Counsel, do we know what the pending charges were against Mr. Roach?
I don't know if they were specifically, my recollection is that they were felony charges and that there had been an agreement or an offer that included a substantial amount of, or some amount of jail time. But I don't think they were ever specified what charges he was facing.
Well, I mean, so we don't know if it was, perjury or something that would go to his trustworthiness?
That wasn't specifically brought out in the transcript.
Thank you.
Justice Doria.
And we know from the record that there'd been an offer. That was what they wanted to ask about, and we know from the record that he hadn't been sentenced yet. But I couldn't tell if he pled guilty yet. Do we know that, or did I miss that?
I don't remember. I don't think that there was any indication of. I think it was just that there had been an offer made, not so much that there was that he had entered a guilty plea. And it was clear that he wasn't given a cooperation agreement in terms of his testimony.
I mean, maybe the state will know, but it seemed like there was some discussion about he hadn't been sentenced, which I thought suggested that he'd pled guilty, but okay, thanks.
Justice Khan.
Thank you, Chief. Counsel, my question is also around this issue of the record. I thought there was some, I read in the briefs and in the part of the testimony that was included, that the court didn't want, what the court didn't want was sort of the offers that were on the table as it relates to the charges that were pending and that he had not pled. But my question is, let's assume it was error for the court not to do this. How did it prejudice your client, given that this witness, part of your argument in your brief is that he places the defendant at the scene, but the defendant admitted in his statement to the police that he saw Mr. Roach, that he saw him with his girlfriend sitting in the car and had a conversation with him. So what about his testimony was particularly, in your view, prejudicial that the jury was not able to hear about his pending charges?
Well, I mean, they didn't hear that he did have pending charges and that he did have a reason, in a sense, to favorably testify for the state. But I agree with you that Roach wasn't as major of a witness as Atkinson. He was more of a minor witness. But he still, he placed the defendant near the scene of the crime, and they were able to impeach about whether or what he said about hearing the gunshots, or whether there were police in the area that might have been involved in a shooting. So that somewhat discredited the defendant also. So he was a minor, not as an important witness as Atkinson, but he certainly was an important witness in this case.
Thank you, counsel. Thank you, Chief.
Thank you, counsel. Your main time is up. Would you like to use some of your reserve?
I would just like to briefly just call the court's attention to the fourth claim, which is the insufficiency of the evidence for the firearm charge. And just, there was no firearm that was ever recovered. It was part of the court made the ruling on this, not the jury. But there was no corroborating evidence from Snow concerning that the defendant ever possessed a firearm. There was none. Atkinson never saw anything in his hand. She did not see a weapon. There was no corroborating evidence. And I will save the rest of my time for rebuttal. Thank you.
Thank you very much, counsel.
That's 4 minutes, Chief.
Thank you. Attorney Baer.
May it please the court, my name is Catherine Baer. I'm a senior assistant state's attorney from the Appellate Bureau at the Office of the Chief State's Attorney here on behalf of the state of Connecticut. I want to start where opposing counsel just dropped off, because I agree that I don't think the exact charges were on the record, ever placed on the record with respect to Mr. Roach. The state would submit that would render this constitutional claim inadequate in the sense if that is a factor that affects this court. But I would note that Mr. Roach's attorney, who was present during a portion of the objections, did indicate, and this is on page 51 of the morning session of the February 11th transcript, that the case has not been disposed of. The matter is still in pretrial. There was an offer made by the judge. So that would indicate that the plea had not even been entered yet with respect to Mr. Roach. On this second.
Excuse me. Could
Yes, Madam
Attorney UWYSTATE, thank you. She did it. She muted her mic.
Thank you very much, Madam Monitor. While we have this break in your argument, Justice Khan has a question.
Thank you, Chief. My question is on this issue of Roach's testimony, and he may not have pled. But the fact that he was, your opponent didn't mention this, but the fact that he was the defendant's cousin, I have to wonder, but for the fact he had pending charges, wasn't that a strong motivation for him to testify against the defendant here, that he had pending charges? I mean, he's the defendant's cousin. And it seems like the court severely limited the ability, how could the defense attorney inquire into bias or against or motive to lie if he couldn't or she couldn't get into at all the fact that he had pending charges in the same jurisdiction being prosecuted by the same prosecutors? It seems like that might be harmful, leaving aside for the moment that he wasn't the only witness who placed him there and that the defendant himself said he saw Roach that night sitting in the very car with his girlfriend. It seems like it could have helped the defendant to have the jury know that he had pending charges with or without a cooperation agreement. How was that not harmful to the defendant?
Your Honor, I think the crux of the issue between on this second claim is that the trial court did not prohibit that. And I would point the court to two separate portions of the record. And again, let's keep in mind, this was an oral objection. So the trial court is ruling on the fly, attempts to clarify it, and did so at various points. The first is from the February 11th a.m. transcript. During this discussion at page 54, the court says, I know you can ask about pending cases. And then she goes on. And of course, and that was a different point of view, a different position rather than what the court had initially said. I would next point the court to the portion of the transcript saying 2:11 a.m., pages 58, 59. And the court specifically says, you are permitted to ask about a reason to favor the prosecution. So it's the state's position, number one, that he was permitted to ask about the fact or the existence of the pending case based on the ruling read in totality. But there were these other avenues for the defense to explore motive, bias, and prejudice, specifically elicit an answer about reason to favor the prosecution. And the final quote would just be on the 2:11 p.m. transcript, pages 3 to 5, and that's when I submit is the most clear reading of the court's ruling when the court says, in fact, in the event I wasn't clear or that the ruling has been misconstrued, and this is a direct quote, that the defendant was permitted to question Roach about anything that is factual that you believe goes to showing interest, prejudice, bias, or motive. And then the court later on says pending cases would be a fact that the defense could use to impeach the witness, as well as the maximum penalty. She then goes on to contrast things that are not a fact in the sense, and when the court is using this word fact, again, read in context, it's clear that the court is saying anything contrary to the plea agreement or the final disposition, the final charges, which are not immutable at this point. We don't know what they're going to be because the case hasn't been finally resolved. So as an initial matter, it is... So
what transcript are you saying this is that?
That last portion is in the February 11th, the afternoon portion, transcript, pages 3 to 5.
So you're saying, if I'm hearing you correctly, you're saying that the trial court later clarified that she would allow inquiry into bias, specifically a fact of pending charges, but just not what the and the maximum penalty for those pending charges, but not what the plea offers had been back and forth. Is that the state's position that she made it clear that page 3 to 5 on February 11th? You're muted, counsel. Sorry.
That is exactly the state's position, Your Honor. Yes, that the ruling was clarified in this after there was this luncheon recess, and that's when the trial court revisited the issue and clarified the earlier ruling.
Okay, so because you would agree with me that if the court had said you can explore bias, but you can't mention pending charges, that there would be an inconsistency there. How can you explore bias if you can't say there are pending charges?
I would, and it was the state's position below that would have been that is an appropriate area of inquiry based on our law. Yes.
Thank you. So I see my colleagues. I noticed, I'm going to refer back to the chief. I noticed that Justice Becker and then Justice Keller have their hands.
Excuse
Attorney
me.
Bear, could you mute?
Yeah.
Thank you.
I don't know. Excuse me. This is the monitor. I don't know if anybody else notices, but when Attorney Bear is on, there's a lot of like sound, airy sounds. I can hear her, but there's a lot of like
Maybe the air conditioner
Yeah.
or something
That's
like
what
that.
That's what I thought.
Yeah, it
Okay, I
goes
just
and
wanted
comes
to.
up. Okay, thank you.
Okay. Yeah.
Yeah, it goes and comes. I'm not sure what that is. Justice Ecker and then Justice Keller.
Thank you, Chief. I just wanted to follow up on this line. I do understand that the restriction or prohibition was not as broad as maybe the defendant suggests, and that as I read the materials, the judge allowed the defendant didn't do it, defense counsel didn't, but allowed the defense to ask about pending cases, and the maximum penalty was one phrase I saw. But I think she made it also very clear, not plea negotiations. Now, I don't know the rules on this, so, you know, it may have been a correct ruling, but it does seem to me that, you know, apparently there was an offer. He was facing a 20-year maximum on the charges, and he was given an offer of, what was it, 8 years or 6 years? And that was a representation on the record. So why can't the jury hear about that? As, you know, we certainly say in many other contexts that jurors have a lot of sense and they can make inferences. So why couldn't the defense put that on and argue as an inference that he was being given this reduction for in exchange for his cooperation in this case?
So there was no cooperation agreement, and that
no, but there was an offer by the state.
Right, and I think the point in not getting into the details of the offer is that they might change, right, by the time the case is finally resolved. And I think there are ways of asking about the pending charges that the defense, in other cases, has been able to exploit that fact to point out to that jury, draw that inference for the jury later on based on the fact of the pending case. So, you know, outside.
Well, counsel, why wouldn't you be able? I mean, there may be other ways, but why wouldn't you be able to say, you know, the state has offered you 12-year benefit here, and I understand you haven't decided whether or not to take it, you know, that offer, but isn't it true that you've been offered in connection with this other case a 12-year discount by the state? And then argue that, you know, argue to the jury that that's because that was for his evidence.
Because we don't know that it's for his evidence. The nature of the offer could be based on many factors that go into plea negotiations, including.
It's just one inference of many. But you know, we allow that all the time. We don't know much of anything. I mean, unless the rule is that there has to be a cooperation agreement before it's admissible, and that may be the rule. I don't know. Is that the rule?
If there was any promise, particularly in light of this court's recent jurisprudence, that would have to be stated explicitly on the record, and that was not the case here. So drawing that inference is actually not supported, because that is not what is going on.
Does the promise have to be? I mean, I'm not sure there has to be acceptance of the promise, but does the promise have to be explicitly linked to the cooperation? Or can it just be coincidental? Because then if it has to be explicitly linked, it would be within the control of the state whether or not to link it.
I mean, my reading of this court's recent jurisprudence and cooperation agreements is anytime there's a wish or a hope for a benefit, that has to be made expressly clear. So that's the reason.
Thank you. Thank you.
Justice Keller.
Thank you, Chief. Good morning, Attorney Bear. You argue in the alternative that this statement from Ms. Atkinson was admissible as a prior inconsistent statement, and in fact, the court rather quickly referred to it as also admissible on that reason. Was that part of the court's ruling, do you think, or do you think the court was just talking?
My reading of the record is that the parties were sort of arguing several different bases while they were discussing the issue, but ultimately it was let in for that B3 subsection purpose, which was the prior consistent statement.
All right, so why would we consider the other one as an alternative?
Because the record also supports it, and
but who would want to put it in? Why would the state want to put in a prior inconsistent statement? And the defendant's vehemently objecting to it. So I'm not seeing that. It doesn't follow to me that the state would want to introduce her statement as a prior. The state's not trying to impeach her.
The state's argument would be that the defense's line of questioning highlighted an omission, and of course under State versus Whalen, footnote 4, that can be an inconsistency. So to the extent that the jury was questioning why there is that inconsistency, the statement for credibility purposes coming in its entirety. Coming in its entirety, by the way, because that was the position the defense counsel took with respect to the admission, and that can be found in the February 14th transcript at page 94. But it would be to give context as to how she did recognize the defendant, to show that this omission was not something that necessarily worked against her in terms of assessing credibility.
All right, thank you.
Justice Daria.
Yeah, I'd like to take a shot at that one. I'm not sure I follow it, because I think you're saying, I thought I read your brief as saying, because she was impeached by an omission, she didn't say in her police statement that that she recognized the defendant's voice. That is inconsistent. So the testimony was inconsistent with her statement. So you want to put it in as a prior consistent statement. Do I have that right?
Which was the main basis for its admission, yes.
No, but I'm talking about under 1.
Yep.
Under 1. What's it consistent with? How is that consistent? She's impeached by saying, yeah, you're right. I didn't say to the police that night or in my statement that I recognized his voice. I take your position about the case law says an omission can be inconsistent. Now the state wants to put in a consistent statement, consistent in identification. I get it, but consistent, that's not consistent with her not recognizing his voice that night.
My understanding is that to the extent that it was inconsistent because it had the omission, it could be viewed in context.
That's not how you're using it. You want it as a consistent statement. She always said it was this guy. You want it to bolster, even though she was just impeached by saying you didn't bring it up. You want it as a consistent statement. I'm not seeing how you put it in under 1 as an inconsistent statement.
So the court is free to reject that argument if it doesn't agree with B1 as a basis and go under B3. I stand by the argument in my brief. I'm not withdrawing that argument necessarily, but I do agree with the court that the B3 argument is stronger and was a proper basis for admission. Ultimately, though, at the end of the day, as was pointed out with respect to my in the questioning rather of my opponent, this was ultimately harmless because while Atkinson's testimony was undeniably important, which the state agreed with and stated itself in closing, the case rose and fell really on Snow's testimony here.
Well, let me challenge that for a second, and then I'll yield to everybody else. He is the co-defendant. Either he shot him or the defendant shot him. That the jury apparently, in acquitting on the murder, may have thought that Snow was the guy. So maybe that's your harmlessness argument, that they got him on felony murder rather than murder. But Atkinson is a disinterested witness, and how is that harmless if she's identifying him as the guy that really got into it with this fella, got in his face and all of that?
because while her testimony was important, particularly in identifying, the defendant being there and the fact of 3 individuals there, it corroborated Snow's testimony, and it did only come in for the credibility purposes, and we can't ignore the rest of the state's evidence in this case. It was not simply Snow's in-court testimony, which was consistent in large and small respects, but it was the inconsistencies in his own statements as contrasted with all the state's evidence taken in totality. And I didn't have room in my brief, and I won't probably have time to go into detailing those. I urge the court to read the state's really rebuttal closing argument, which is a roadmap through contrast of state's Exhibit 98, which is the defendant's written, with state's Exhibit 1, which is the video interview that the defendant later on, as well as incorporates other evidence as well, as a really clear and concise statement of the power that these small and large inconsistencies creating this overwhelming state.
If Chief, can't see if there's other questions. If there, I was just going to ask one other question of inquiry.
Justice Secretary does have a question. What?
Please.
Oh, no, go. You go. You're not older. All right. And you're on a roll. So go.
Let me. I'm not sure I agree. This is a constitutional issue. Let me see if I can put it this way. Time that a witness something more than what is in the. So she tested to X at trial. I mean, that's hearsay. And she said, and by the way, here's another that here's another way. If she's that, put this police statement. How is that right? Fair. That she can put in, one more thing. You can't say a word. Police statement's going to come in. The ruling.
The court, you're not over this case, in which case they permitted it, but this is the court's discretion. Defense objection made below that the state limited in some respect.
What's a discretion that in or have kept it out? What I mean, if you're going to put in time, just bolsters right, which
might be the is how much or the state technique. If once with one witness, the court would consider of, for example, short snippets in LeVar Roach's for a different purpose, instructed those statements. That'd be a call for the judge, the arbiter. It's a fair proceeding. That call.
Further, Justice Story?
all set.
Justice Sacker.
Horse I that and counsel, you can answer. It's just that you and some, speak up, I guess. I get why it's really a consistent statement. That doctrine is the consistency has to be relative, impeachment focused on. Yeah, I said just making it up now. This is a of what I've. It's in that sense. It's pointed out, she never said that she recognized. That's the and the does facilitate around that. Consistent, you know, consistent with is I mean, so I just don't. To me, to fall not way, but out of the, and you're not giving. I guess I
to be our students, but that right, really bolsters in terms of him and able. So on that, it bolsters not withdraw. I will rate the defense that the instruction, specifically instruction, can't consider in that's the February transcript 10 follows. For testimony of Cheyenne, I permitted the introduction statement exhibit during question, omission, or recent fabrication or written statement. This to the extent that you weighing only would be that the other factors sometimes is you, but that closes the could have, because of course they were expressed purpose.
Keller, do you have anything further?
I'm not really, you know, it may be to the matter that for any other, they're kind of left in the dark. I mean, I just thought that was mission. That statement prior from her prior would have recognized.
That's fair.
So there's nothing about how it's void.
It's not. It does, of course, that she heard this individual
Yelling. But was she time or okay?
I just want to the last that means, of course, establish firearm. I concluded the point. Both of us have not. The state's position is the trial court effective sentence years that consecutive under our law would be the opportunity sure that it's set under the aggregate. I think came up with this questioning. The jury mean that they didn't found that intent, felony murder, defendant or with committed either cause the contact well beyond, and this goes as well the victim identification earlier that shown in video, and when in fact from Lord Snow's murder was charged. You know, it was based on any other questions.
Thank
I would ask you.
In state, Judge Diori noted that direct exam, her also asked her prior to refresh. So that was her, as they were concerning how did you, that's when she conversations and that and I this elicit this, whether voice be able to question about consistent unfairly the I think this where she states statement she knew his, yes, familiar with the defendant as she recognized she read and she so it that recognizes because that and it would be a state be able to question but that
Counsel, there are questions. Story.
Quick.
Yeah.
I guess I don't get it. Trial court tried this and it testified that possessed the gun.
The co-defendant, I think there's the other co in this case at all ever possessed except from Snow's.
Under our case, it
doesn't be corroboration. You also have to look at the verdict that they didn't testimony and they have been the shooter because of the murder. They could have made intentionally, but Snow so that it was 3 shots.
But maybe thought different. Jury thought, right? I mean, it was up to the trial. There may be an inconsistency between the jury verdict and the. That's okay.
Yes, I think it's just a fact. Again, there's no other corroboration. There's no other evidence here that he's carried a silver gun or many other witnesses that saw him that evening. No one testified he had a gun on him or he hid a gun or there was something with a gun. Nobody saw a gun that night on the defendant.
Thank you.
The other thing I would like to also mention is the second issue.
Counsel, before you do that.
I'm sorry.
Justice Daria. Thank you.
Thanks. Why isn't the state right about harmlessness given the verdict for felony murder? I mean, why don't we construe that to mean that the state believed that Snow shot the victim and the defendant helped rob him? Is there another way of interpreting the evidence?
That Snow shot at him? I'm sorry. What?
Well, I mean, they didn't convict him of murder. That's your point.
Right.
But he was convicted of felony murder. So, I mean, at best, I'm thinking, unless you tell me differently, at best, the jury believed that Snow was lying, that he wasn't the guy that shot him, that the defendant did, but they were both there and robbed him. I think that's the state's point, is that, so, I mean, what other way is there to interpret the evidence, not just the verdict? But isn't that a fair reading of the evidence, even if there's error?
Are you talking in terms of the possession of a firearm charge?
No, I'm talking about, I mean, the defendant's own statement puts him there.
But his statement was that he wasn't involved, though, that he lived in the neighborhood, he was walking around the streets that night, but he wasn't involved in the robbery and the shooting.
But Atkinson's statement at least puts two people, put aside whether she heard his voice or not, at least puts two people in the dust up that ends up dragging the guy to the vacant lot. I'm just not seeing, tell me what's the evidence? How would you otherwise interpret a felony murder charge when the co-defendant said, that my co-defendant shot him, and they didn't go with that? Or maybe there was another reason?
Yeah, I don't think I quite understand what you're getting at it in terms of, yeah, obviously they felt that he was a participant and he was found guilty of the felony murder. And so I'm saying that even how is it harmful if they at least the Roach issue and the Atkinson issue still leave evidence? If you take those out of the picture, they still leave evidence, albeit Snow's, but there's, I guess there's other corroborating evidence that would make him guilty of at least being involved in the robbery that led to this. I think that's where I disagree with you, that there is not other corroborating evidence that he was even a participant in the crime, that he may have been in the area right prior to the crime, but his defense was he wasn't participating, and there was no one else that testified to those actions right before. Atkinson's if there was error as to Atkinson, it was yes. As to the statement coming in. She still testified that this was the guy. So there is that. And then he said. There also, the jury was deadlocked, and at one point they asked to hear some other testimony, but it was after they asked to hear Atkinson's testimony that they convicted him, or they came back with a verdict. And I think that shows the importance of this witness, and anything that could have, she was a crucial, critical witness that was independent or non-biased. Anything, they also had the whole statement in the jury room with them. So anything that could enhance or help with their decision, and I think that that's where the prior consistent statement comes in. Anything that could help to bolster her credibility. And that's where the harm came in. And in terms of the jury instruction, in terms of
counsel, you're almost 4 minutes over now, so if you'd like to wrap up, you may wrap up.
In sum, I think that this statement was entered in error, and we would respectfully request that this court find harm and reverse the defendant's convictions.
Thank you very much, counsel. With that, that's our last case for today, so we will adjourn until tomorrow. I want to thank counsel for coming in to do this virtual hearing. We've had pretty good year of hearing cases despite all the troubles, and it was because of counsel like you. So we appreciate it. Thank you very much. We are adjourned.